Come to order. Good afternoon, everybody. This recommending committee is now called to order. Are we in compliance with the open meeting law? This meeting has been posted in various locations throughout the city, and we'll turn to item number 3, which is the first bill on our agenda. That's bill number 2007-62, annexation number ANX 23477, property location on the east side of the Pulley Road alignment, 660 feet south of the Ann Road alignment, petitioned by Southwest Desert Equities, LLC, acreage 5.15 acres, zoned RU, county zoning, UPCD, city equivalent, sponsored by Councilman Stephen D. Ross.
This is a routine owner petitioned annexation. Everything's in order. Recommend approval.
Do we have any comments from the audience? From anybody who is participating in this exciting meeting? All right, do we have any comments? A motion?
Move for due pass.
All in favor?
Aye.
The motion is a due pass. Okay. Moving on to the next item, bill number 2007-63, granting of a franchise agreement to AT&T Communications of Nevada Incorporated and setting the purpose, character, term, time, and conditions of the franchise agreement. Proposed by Mark Vincent, Director of Finance and Business Services. Is Mark here?
I guess I might do this if he's not here. This is a non-exclusive franchise that we do from time to time with different companies. The charter indicates that we do this by ordinance and attach the franchise agreement. It gets a little bit out of sequence because the actual public hearing that has to be held will not take place until your council meeting where this is eligible for adoption. But we put it in the process here so that it's ready to go, and recommend approval.
Any questions from the members of the audience? From our councilman?
No comment. Just move for due pass.
All in favor?
Aye.
The motion passes. Moving now to the next item 5, bill number 2007-64 provides that Planning Commission action on most special use permits is final, unless appealed or requested for review by a member of the City Council, and modifies certain provisions regarding related hearings and appeals so as to conform to state law, sponsored by Councilman Gary Reese. Any comments from the audience?
Yes.
Let's have Flynn present it first.
Oh, sorry, Finn.
Flynn Fagg with the City of Las Vegas Planning Department. Just very briefly, what this is proposing to do, as it states in the title, is that Planning Commission will have final action on most special use permits. The exceptions to this would be where there are multiple applications filed together, such as a case where there is a site development plan and a special use permit that will go together. In those cases, those special use permits would also go on to City Council. And then the other exceptions would be where a council member may request to pull a special use permit forward to City Council for consideration, or where there's an appeal of a decision by Planning Commission. This is consistent with the method for approving special use permits with other agencies in the Valley, and consequently it is recommended for approval.
Thank you. Yes.
My name is Teddy Russell. I'm a resident of Las Vegas. I concur exactly and entirely with Mr. Flagg. I know exactly what the Mayor Pro Tem has in mind by virtue of the fact of my attending many city planning commission meetings. And it's also on the order of what they do in Clark County as far as zoning. It's a great expediting factor, but it still leaves a resource for appeal, so I recommend approval.
I would just like to comment. Did you have any comments you wanted to make?
Yes, go ahead, please.
I just wanted to comment that I have talked with some people, and I've had calls and a couple of other communications from individuals who are very concerned that this takes more away from the public meeting, and it also takes away some of the authority of the council. I have even talked with my maximum number with whom I can talk, 2 others, and they were not in favor of this because of that. I was not able to talk with Councilman Reese, but I do think that there's a concern about that. Number one, because my thought is, this was my thought, we're coming up at the same meeting for a raise for our council people and our council, and at the same time, we're taking away some items that the public often wants to know as a matter of information. They feel that too much is done not in the public eye. And so I had a concern there. And secondly, because there is a feeling that, and broached to me by several others, that takes away the authority of the council members. Do you want to say anything else?
Yes, I do. After reviewing this, I too have concern in regards to the special use permit being a final decision, laying it on the bed of the Planning Commission. And that's something that I would like to make a decision on as it relates to items that come up in my ward. I want them to come before me. I don't want it to be the final say due to a lot of the important issues that arise around special use permits. And taking that authority out of my hands is not something I'm willing to give up. So I'll make it a point at this recommending meeting, as well as on the council, that I will not be in support of this particular item.
Well, if he's saying that, and I've said what I've said, it's pretty obvious there are 2 negative votes here. And the only thing I could think is if the 2 negative votes come, then maybe it could be taken, it could either be dropped or else it could be taken back and maybe fixed. But right now, I mean, you say that, for example, we've had trouble in getting some of the planning information. We've had getting it in enough time that we can do the decision-making process. I've had a couple of cell towers that went up because they came and I didn't get it in time. And I'm not really...
Administratively.
Administratively, yes. And so then by the time, 10 days isn't that much time if you count the weekend, and if it's a week like we're very, very busy. So that's why I have a concern too. So you might be able to do that. I don't know how you would prefer, but I could call for the vote now, and unless there was something else, you're the one who has to make the motion.
Well, my motion would be to move forward with no recommendation for the sake of the sponsor, but I still stand on the record that when it comes to special use permits, those are items that we as a council address on a daily basis. There will be an item coming up before the council that we as a council have to address, a special use permit that was voted on by the council. And I can see in the future, if in fact this is voted on by the Planning Commission, it would make it very difficult for the council not having had its say, if you will, before us, having to work extra hard to try to pull that item back before us again. I'm not fully clear on the idea as to why, in fact, well, I am clear as to why, in fact, it's recommended that we move forward to lay this on the shoulders of the Planning Commission, but I don't believe that this particular use should be that item to be placed before the Planning Commission, because it's a very heavy vote to many industries, and taking that out of our control as the elected body, I believe we would do our constituents as well as ourselves on case-by-case base a disservice.
Would you like to make a motion?
I would. My motion would be to I would actually like to table this item and have more discussion. So I'm not really sure.
And I understand understand that, because that might give time to work on it and have some discussion,
Certainly. we'd be happy to
rather
do that
than
with you.
tomorrow having such a short time.
Yeah. I would actually like to have more discussion about it. I'm not sure if the council will, I believe we're have a meeting coming up where
We do have a special meeting coming up.
a special meeting coming up. I'm not sure if that's a platform to address this, but possibly during our individual briefings, have that discussion
We would be happy
to come in and do that.
Council, let me suggest that rather than tabling it, which implies indefinitely, if you could hold it in abeyance for a time certain. Otherwise, the council may never see it, and that would be the two of you voting something. The council is entitled to at some point hear it, even if you don't like it. So rather than table it, if you could 4 weeks, 6 weeks, whatever you have in mind, that will make sure that they eventually will see it.
Right.
And we could do it to get past the holidays, because we have so few working days between now and January.
Yeah, I would say possibly the first or second meeting in January would be great.
Okay, which one?
Second.
Okay.
So my motion would be to obey this item until the second recommended meeting in January. That's my motion.
All in favor?
Aye.
The motion passes. Moving now to item number 6, Bill number 2007-65, amends ordinance number 5597 pertaining to the creation of Special Improvement District number 809, Summerlin Village 23A, proposed by Charles Kajowski, Director of Public Works.
This is an existing SID that there's an amendment to the project costs and some of the descriptions within the district. So we need to go through this amendment process. Everything's in order. Recommend approval.
Are there any questions from the audience? Anybody present? Mr. Councilman? Councilman?
I would like to move for due pass.
All in favor?
Aye.
The motion passes. Item number 7, Bill number 2007-66, repeals ordinance number 5916 pertaining to the creation of Special Improvement District number 811, Summerlin Village 24, proposed by Bradford R. Jervik, City Attorney.
Yes, thank you. Mike Thompson, Department of Public Works. This is an improvement district that was created back in July of 2007. Since that time, the owner of the property has come forward and requested that the assessments be postponed on this property. And so in order to do that, we need to repeal the two ordinances that created the district and also levy the assessment. And that's items 7 and 8 on today's recommended agenda. And we would recommend approval.
Any questions or comments from the audience?
Move for due pass.
Councilman? All in favor?
Aye.
Aye. The motion passes. Moving to item number 8, Bill number 2007-67, repeals ordinance number 5917 pertaining to the levy of assessments of Special Improvement District number 811, Summerlin Village 24, proposed by Bradford R. Jervik, City Attorney.
Yes, thank you. Mike Thompson, Department of Public Works. Same comments as the previous item, and we would recommend approval of this item.
Any comments from those present? Mr. Councilman?
Yes, move for due pass.
All in favor? Aye. The motion passes. We now move to item number 9, Bill number 2007-68, updates the zoning regulations that govern off-premise signs, sponsored by Mayor Oscar B. Goodman.
Madam Chairman, Councilman Chris Knight, Director of Admin Services, want to give you a brief update as to where we are. I think that you've been briefed numerous times on this issue in this ordinance. Coming out of the state legislative session for 2007, there was Assembly Bill 438 that was introduced to make changes on the regulation of billboards. There were subsequent attempts to amend other billboard legislation Our council, through the mayor, asked that the state legislature send the billboard industry, at that time represented by Lamar and Clear Channel, down to discuss the billboard regulations with the city of Las Vegas and give us the opportunity to resolve this issue at the local level. The legislature concurred with that and asked us to work with them. Before the legislature even ended, we began negotiations with the billboard industry. We invited all of the billboard companies into our meetings because the regulations that you adopt affect everybody. And we sat down. There were principles of the meeting negotiations. The billboard industry had 3 primary objectives. So the city of Las Vegas expressed its objectives. The 3 primary objectives of the billboard industry was to, 1, have a consistent review period for existing billboards with required reviews and future billboards. 2, to have the ability to raise and relocate billboards over sound walls and roadway improvement projects in conformance with the existing state statutes, so they could retain their visibility along freeways. 3, maintain non-conforming status and business viability of those billboards that currently meet the non-conforming status definition of state law. Those were the objectives of the billboard companies. The objectives of the billboard industry, the objectives of the city of Las Vegas was, 1, to fulfill our commitment to the state legislature to negotiate in good faith with the billboard industry to resolve issues identified in proposed legislation. And 2, to maintain the city council's ability to determine what's best for the community in making a yes or no decision on land use entitlements related to billboards. We asked the billboard industry that they speak with one voice because there are multiple billboard companies that do business in the city of Las Vegas and that we deal with on a regular basis. They agreed with that, and for the most part, through the negotiations, did speak with one voice. And we were able to come with proposed major ordinance changes related to the establishment of a 5-year review for all billboards. That all billboards that have a required review, that those required reviews would go to 5 years. And we have since had discussions with some of the council members, and there are a couple of issues related to the 5-year reviews. That, 1, the 5 years go beyond any term limit or existing term of a council member. And that, in other words, if a council member's term is 4 years, if you approve it the first year of your term, you would not see it during your entire term again. And then 2, that there are the changing circumstances in the city because of the rate of growth at which we grow at that may warrant having another review within 5 years. That was presented to the Planning Commission on September 13th. The Planning Commission felt and has recommended to the council that that 5-year review period move from 5 years to 3 years. The height adjustments for sound walls, we were able to reach an agreement on the height adjustments for sound walls to allow billboards within 660 feet of an interstate highway to receive an administrative approval to raise the height of a sound wall to 45 feet measured from the top of the noise abatement feature of the sound wall to the top of the billboard. But in no circumstances would the administrative approval be allowed to be given for any billboard greater than 65 feet in height. The current ordinance restricts a billboard height to 55 feet. So we gave them an additional 10 feet. They could go 45 feet above as long as they stayed within that 65 feet. They could go up to 65 feet. But if they go above that, that would have to come forward to the city council for your review and approval. Okay? Retention of non-conforming use status. There was an issue related to changing non-conforming billboards that currently, under current operations, if a billboard has non-conforming status for whatever reason, because of spacing requirements, because of the time that it was built, it was in an area that the zoning allowed the billboard, but the zoning changed and no longer allows the billboard. There are myriad reasons for a billboard having a non-conforming status. That if you wanted to upgrade that billboard, say put on an electronic message board, you would have to come forward to the Planning Commission, City Council, get a special use permit. As a result of that special use permit, you would be required to have a review period. And under state statute, if you have a review period, you're not a non-conforming use billboard anymore. And the billboard industry wanted to be the ability to retain that non-conforming use status. It seemed to make sense to us that if they're making those kinds of changes, that it should retain its non-conforming use billboard status and still be a viable entity in their business structure. So we did agree to that, and we have recommended that in the ordinance that you have. Those are the three issues that were the major issues that we had to address. There were other issues related to final inspections. One of the things that we were very adamant to the billboard industry about is that sometimes they do not get final inspections on billboards, and they need to get them. They've assured us of that. We worked with the Building and Safety Department Director, and he has worked out a way in which they are able to hire a consulting firm to go out, physically look at the billboard, and do a final inspection for the billboard industry, which expedites that final inspection and puts the city in a good position to say that it has appearance of being safe and sound. And we can get those on not only new billboards but also existing billboards when they want to change them. Other proposed ordinance changes were embellishments. The ordinance currently does not allow an embellishment. We agreed that they could have an embellishment where the embellishment could go 5 feet above outside the 14 by 48 message panel, but it could not exceed more than 50% of any linear side. That it's also restricted in square footage, and I'm trying to remember what the square footage was, and I can't remember off the top of my
So
head.
what you're telling us now is in addition to the
In addition.
3 points.
Yes, ma'am. They were able to show us some billboards that are approved in the county that have embellishments that are non-offensive. That is a practice that's allowed in other communities, and we looked at that and said it appears to be reasonable to do that.
Question. Does that include text?
Yes, it did include text. So, and our ordinance does not allow text at this point in time. So, those issues were also issues that we agreed to. The biggest issue that has come forward since our negotiations is the last issue that I want to share with you, is that is the issue of once we decided that they could come in and get a special use permit for a billboard to change it, to add electronic message panels or make minor changes to it, the question then became, well, with a non-conforming billboard, a lot of times you have billboards that are unattractive in the community that have a less than enhancing quality to the neighborhood. We asked them, they proposed and said, well, is there any way you would ever consider allowing us to take down a non-conforming billboard and put it back up? And we said, well, how long would it take you to take a billboard down and put a new billboard up? And the industry said on the average about 60 days, but they would like a 30-day wobble room in that. And we said, well, if we gave you 90 days to take a billboard down and put it up, you would have to notify us that the billboard's coming down. If the clock starts ticking, you've got 90 days to take the thing down and put a new one up. If you don't get it, if you take it down and you don't get it up within that 90 days, you then lose your non-conforming billboard status. We had an agreement worked out. At the 11th hour, some folks came in and asked the question of us, does that right, the non-conforming status, go with the billboard or does it go with the property? And it is the property that is the non-conforming status. It is that site that is non-conforming. Spacing, because it's zoning or whatever else. And we said the non-conforming status runs with the land, not necessarily the billboard. That brought to light an issue of who has the right to take the billboard down and put one up. Is it just the billboard owner? Or is it the property owner as well? And the reason that becomes relevant is because there's an issue that most of these sites are leased sites from a property owner, and if the lease expires and the property owner wants to be able to market their site to someone else, another billboard company, or another billboard company then wants to be able to compete by offering a better deal on the lease, does the property owner get that right to do that? And we felt that that was a free market issue, that wasn't something that was up to us to determine. So in the attorney's office, in writing the language, just said that the owners of the billboard have to apply. And that could be the current owner, or that could be a new owner, and the property owner. That we had to have the owners of the billboard and the property owner on the application. The planning commission, when they reviewed it, said, we just want it to read applicants, which did not clarify the situation at all. While we may agree with them on the 3-year review period, we don't agree with them on the language that they put in for applicants. That has created quite a bit of discussion. On October 4th of this year, we met with the mayor, who has sponsored this bill, with several of the representatives of the billboard companies and those representatives of those property owners that want the ability to make this change themselves. And the agreement at that time, in that meeting with the mayor, was that the section dealing with being able to take a billboard down and put a new billboard up would be taken out of the ordinance. The billboard companies, this is where they fail to speak with one voice now. And the billboard companies would be given time to see if they could work out an arrangement that would make everyone happy between the property owners and the billboard owners, and give them until January, the end of January of 2008, to come back with a proposal. That the ordinance, because of our commitment to the legislature, could go forward with the 3 things that we did agree upon, that were the 3 primary issues of the billboard industry, that ordinance could move forward with the council. We would take out the issue dealing with property owners versus billboard owners, give time for them to work it out, speak with one voice to the city of Las Vegas, and come back and we would do a new ordinance that addressed that issue if it were appropriate. Otherwise, the council would be asked to make a decision, do you want to do this or don't you? And subsequent to that, I have had phone calls from Orion Billboards, Mr. Bo Polly saying and I don't intend to speak for them, I'll let them speak for themselves, but the indication to me was they didn't feel that the situation would change between now and the end of January, and they would like to see the council address this issue now. So where we stand on the thing is the ordinance that you have in front of you, with the exception of the 5-year review period, moving to 3 years is something that we could fully support. It keeps the city neutral on the owners, billboard owner, property owner issue. You have options. The options that you have is you can take the ordinance as indicated, as presented to you. You can take and amend the ordinance to favor one side or the other on the issue, or you can take that issue out altogether. And those are the options that you have in this ordinance and considered. We do recommend that something be done by the council. I have here a letter from Senator Warren Hardy, who is the chairman of the Senate Government Affairs Committee, supporting that the city do something. The purpose of his letter, I'll just quote from the last paragraph, the purpose of this letter is to convey my support for this issue being resolved at the local level instead of at the state legislature. I hope the city council looks favorably on adoption of the text amendment that addresses both your concerns and that of the billboard industry. I know that the compromise language has taken a great deal of time, and I hope that will finally be resolved. I think that his appeal to the city of Las Vegas is please adopt something and don't let it come back to the legislature.
But wasn't the entire ordinance, including the 4th item, included in what was sent to him? And wasn't that letter a reply from him on having seen the complete ordinance? Okay, so he's not saying anything just about the 3.
No.
His saying, I approve it, and I hope you all go through with it, is relating to the 4.
I think what his message
And I
was,
think that's
because
important to
is-
say,
is
because-
just do something, and he knows we have kept him apprised of all the issues. He understands them, and he understands that we have been able to work out a deal on the 3 main issues that came forward. He's supportive of that, but at the same time, he wants it to be a local decision, and he's asking that it be resolved locally so that it doesn't have to go back to the legislature.
But just remember, his words of praise were on the 4 together.
Yes.
I just want to make that point very clear. Secondly, could I just get back, when you talked about the embellishments, including the text and 2 or 3 other things, are those now going to be decided in favor of what the billboard industry wants? That's what you're saying, right?
Yes.
Okay.
We agreed
Then-
to allow embellishments and allow embellishments.
Okay, then my third question is, the very first year I came on the council, I spent an extremely large amount of time working with everybody I could work with, coming in very naively, thinking everybody wanted to work together and all that. And we got nowhere. Over a period of 18 months, I didn't see the billboard side budge one single bit. And in fact, now, things that we were asking, will do, you have this that you want, and we have this that you want, those types of things, I see that, quite honestly, what is it that the city wanted originally, not that long ago, that we obtained as a concession from the billboard industry for these things that they wanted?
I'm not sure of your question.
Okay, the question is this. When we met over that period of 12 to 18 months, there were things that the billboard industry wanted. There were things that planning wanted, our planning and development department wanted. And I want to know, I see the things that the billboard industry wanted included in this. I'd like to know what is it of all the things that the planning and development wanted that they got. Where was the compromise? I just want to know what the compromise was.
I don't know that there is a compromise, Madam Chairman. I think the issue is one of protecting the city's interests. And if I can go back to the objectives that we went into the negotiations with, and that was to protect the city's interest in being able to say yes or no to billboards.
And you were doing that because of what
because
pressure.
of the threat of the legislature.
But we went past that even in some of the things we did. The embellishment thing, I don't believe, was a big issue at that time, but we gave that. Anyway, I've been so discouraged in seeing the process worked within the billboard industry.
Also, the embellishments is not something that's acceptable to the council. The council is free to remove that requirement, that agreement from the all of our negotiations from a staff level. We made it clear that this has to have an up or down vote from our city council, and the council is free to do that.
And my comment is only on the process.
Yes, ma'am.
It's not that I have a terrible anti-feeling against moving this embellishment situation the way you're moving. That isn't it. My comment is on the process. And that's why, quite honestly, for what I've seen of the process, I don't know what waiting until after January is going to do to help people come together. I haven't seen much coming together with anybody, with our staff, with little groups, big groups. I haven't seen it since I've been on the city council. And now I've said what I wanted to say. Is there anybody else who would like to make a comment here? Would you like to make one?
No, I would like to hear from anyone in the audience before I make.
Okay, I think we'll have several. Anybody here want to make a statement?
I'll start. With the chair's permission. Jay Brown, 520 South 4th Street. First of all, we said at the Planning Commission, I think one thing we all agree on, that we're very, very pleased with the time that Chris in particular and the staff has spent on this matter and the attention they've given us. I have two just minor, I'll say it, I don't know, I used the word, maybe corrections or additions to what Chris said. One, I'm really only addressing the fourth issue, the last issue, okay? And that issue is simply this. Not only is it as he said, a free market, what about the property owner itself? What if the property owner wants to keep that billboard and not even use a billboard company? Okay? The property owner, assuming he's not in any breach of any contract with anybody, who has a non-conforming billboard, should be able to do whatever he or she wants. He or she got the use permit, and he or she should be able to go ahead within a reasonable time and replace it. And he or she already has the use permit and shouldn't have to get another use permit. Should they have a review? Of course. But they don't need another use permit. So I wanted to add that to just the property owners. The second thing, let's go to the meeting with the mayor. The mayor spoke with me publicly, and at that meeting he asked, as Chris rightly said, that he would like to just see the first three discussed now, and he'd like to see the other one put off until February with the hope that those of us who had differences could meet. That's absolutely what happened. I said to the mayor, I can't make that decision. I'll go back to my clients. I'll make that recommendation, and we'll go from there. I went back to Mr. Pally, one of the people I did go back to, from Orion, who's sitting to my right, and his view basically was, Jay, our company's a team player. If the city council wants to delay this until February, that's fine with us. But we want you to point out that while the ordinance is being discussed. We don't want to come in February and then find out someone says, well, if you had this problem, why didn't you talk to us when the ordinance was before the city council? Why did you wait until February? So he said, please go on record and say that I'm ready to do it now, but I'm not going to be argumentative. If the city council, in their infinite wisdom, wants to go in February, fine. I don't believe, Jay, our interests with some of the other companies are so diverse. I don't believe, as good a negotiator as you and Chris Kempfer may be, I don't think you can work out this problem, okay? You can't put toothpaste back in the tube. There's certain things you can't do in life, and even you and Chris can't do this. But if that's what the city council wants, fine. I might add I had another conversation with the mayor after that, and I don't know that his feeling is the same, because Mr. Rapali asked me, he said, ask the mayor, ask staff, if we put this off, why will one of us be more happy in February than we'll be now? One of us is not going to prevail on our point. And I'm not going to be happier in February if I lose, and I can't believe that Mr. Kemper's client is going to be happier in February if they lose. And the legislature doesn't meet until 09, so why not do it now? But again, for the record, we're not trying to be argumentative on the point. If delay is what the council wants, so be it. We just want to go on record as saying that we do want to make sure we have our day before the council, whenever it is. I think Chris covered about everything else. And I think that's all I have to say at this time.
Is there anybody else?
Thank you, Councilwoman. Paul Larson, 300 South 4th Street, representing Clear Channel. I think I agree with everything Chris Knight said with regard to the first 3 points. The first 3 points were in direct response for legislation that was proposed and then withdrawn pursuant to an agreement with the City of Las Vegas to try and address the issue locally. With regard to the fourth issue regarding the upgrading of existing non-conforming billboards, and let's be very, very clear, that's all we're talking about. We're not talking about billboards that have a use permit. We're not talking about billboards that are otherwise within the regulatory jurisdiction of the City of Las Vegas. We were simply talking about old boards that are non-conforming, which means that they stay up as long as they're up. The City Council doesn't review them. They're not subject to a use permit. They're not subject to any kind of regulatory oversight. The problem is, as the billboard industry, we can't upgrade those because they're non-conforming. In some cases, in most cases, in order to replace those or upgrade those, we would have to pull building permits in order to replace a foundation. The example we always point to is Wholesome Lofts. There's an old non-conforming board that is basically 2 steel I-beams stuck in the ground with the billboard on top. That is definitely not current building standard. That is definitely not current industry standard. To upgrade that, we'd have to take the existing billboard down. We'd have to get a building permit to replace that with a current conforming to building code, conforming to industry practice type of billboard. Now, in that particular location, because of distance restrictions and other requirements, we would not be eligible for a use permit. And a use permit is a prerequisite to a building permit. So there's no way under the existing law we could upgrade an old board like that. So the intent was simply to provide a means for us to upgrade those old boards without subjecting them to a use permit review. For example, if you're spending hundreds of thousands of dollars in some cases, if we're talking about a LED board, getting close to $1 million for a board, we want to have some guarantee that the capital investment that represents is going to be recouped by allowing the board to stay up long enough to recoup that through revenue derived from the board. So we wanted to preserve the non-conforming status of those boards, but at the same time allow us the ability to pull building permits in order to replace or upgrade them. That was simply the intent. At the last 10 minutes of the last meeting, Mr. Brown came in and proposed the issue that he's talking about now, which would allow anybody to come in and do that. To the extent that there's a departure from what the original intent was, we have a problem with that. And to the extent that the industry is speaking in less than one voice or more than one voice on that particular issue, we think that the compromise reached in the mayor's office is the best way to address that. That is, the three issues that the legislature has asked us to address pursuant to the agreement to withdraw the legislation that was pending, we have addressed. The fourth issue, since there's no consensus on it, let's withdraw that if the appetite of the city council is to address it through another ordinance. If the appetite of Mr. Brown is to force the city council to address that, let's do it through another ordinance. Let's not delay the compromise legislation that was the result of the legislative action. So we would ask you to implement the agreement that was reached in the mayor's office, and that is go forward on everything but the provisions regarding the upgrade of non-conforming boards. And that would be the 90-day provision that Mr. Knight talked about. And with regard to the process, I participated in every single meeting regarding the last time that the council floated an ordinance. And at every single meeting, I specifically asked for someone to articulate what the concerns of the council were, what the concerns of the planning department were, so that perhaps we could reach different language to reach the same points. Never did anyone articulate the points that we asked for. Instead, the way we perceived the ordinance was a very anti-billboard ordinance, and the intent was simply to make all billboards go away. And when I said that in public meetings, not a single person from staff disagreed with me. So we had no choice but to oppose that ordinance. This one, conversely, is the result of consensus, is a result of very hard work on behalf of Mr. Knight, and I think it shows that the intent of the city and the intent of the billboard industry to preserve the discretion of the city council to regulate these boards has been preserved. And that answers your question before, is what does the city get out of this? The city maintains the ability to continue to regulate these. And I think that's very important, and we agree that in most instances that's done very, very well. The sole instance that we're asking for some additional latitude is raising boards above public works projects, sound walls, that sort of thing. Consistent review periods as opposed to 6 months, 1 year, 2 years, that sort of thing. Let's just have one review period so that we can plan in terms of business modeling when that billboard would be reviewed again and when it would be subject to possible revocation and replacement. And then the last one is maintaining the non-conforming status of billboards that are going to be raised pursuant to the second point, and that is pursuant to maintaining the visibility. Those three issues were our key issues. Everything else, if in your discretion you do not want to enact that, we support that as part of your discretion. So with that, I'd be happy to answer any questions you might have.
Well, I would just like to say that I thought we articulated in writing the purpose of that. Were you talking about that first 18 months that we worked on it when we were attempting to do it? Were you just talking about the second time when you said nothing was articulated?
No, I think the second time was night and day compared to the first time.
What?
Was night and day. Mr. Knight, the first 30 seconds of the first meeting, laid out what the city council's objectives were and said these are non-negotiable points, and if you're not willing to address these, we're not willing to talk. That laid it out clearly for us and laid out what the city's points to die for were, and we were able to reach consensus on issues that were important to us without infringing on the issues important to the city. With regard to the previous process, I don't think we ever had that kind of clarity. And when we consistently said we think this ordinance is very hostile to this industry, and as we construe it, it will make all of our locations subject to possible challenge, subject to possible amortization. It's just a disguised way of making the billboards go away. And frankly, in one of the meetings, I believe it was one of the deputy city attorneys specifically said, you know, we have the power to make billboards go away. We just don't want to pay you to make the billboards go away. That's why we're doing this ordinance. I'm not making up that.
30 million or something? What was it? How much would it cost to get rid of a billboard? Forget that.
It's expensive.
That's not important. It's expensive, yes.
But I agree.
Of course, and it's public monies, and that's why I don't know, having been at those meetings, I don't know if it was true that what you're saying. That wasn't my view of it. But you see, because that meeting was not to come in and say, this is what we want. That was to say, what is it that, what are the changes that we feel planning development wants, and let's discuss them with the industry and see if we can come to something that is workable. And industry can add what they want, which we did, which we have written copies of. So I think that shows that it was that type of coming together of ideas. We certainly hadn't been through the legislative situation that you all were and been put in that situation. It was supposed to be a meeting of ideas and getting input and things along that line. Can I ask you, if I wanted, let's say, I just want to know what does remove a billboard. If the council or the council person feels that a billboard is not appropriate for an area because of the way it's grown and everything, and the ambience of the area is totally different, or if there's some other problem. And so they move to get rid of the billboard, or to remove the billboard. And then that goes to the council. The council votes to remove the billboard. And the billboard isn't removed by the billboard industry because they go to court. And they go to court and they say, these are the reasons why it shouldn't be removed. Well, the court rules against them too. So the local courts rule against them. And so then what happens is they appeal to higher courts and higher courts. It's very difficult. I don't know if I've seen one taken down yet since I've been on the council. It's not an easy thing to regulate billboards if they don't belong there. That's one of the things that I would say. I haven't seen it. And in fact, I'll tell you what I do object to. I object to members of the billboard industry telling other people that are residents of the ward which I represent, yeah, we took it to court, but don't worry, we have deep pockets. We always win. And that was the exact quote that came to me from someone. These are the things that I am concerned about. I am concerned about property rights. I am concerned about a gentleman now who has bought some land and there's a billboard on it. He doesn't want it anymore. But through some type of legal arrangements or something, even though the council has voted to have that billboard removed, and that council has won on the local courts, it's still up there. And I don't know whose company it is, by the way, but it's still up there. And the person who bought the land recently, he wants it removed, and he can't get it removed. You know, it's very difficult, and I don't know if these should be life-sustaining situations with billboards. I wonder where the property rights of the individuals owning the land come in.
Well, it's interesting you bring up property rights. I'm aware of a couple situations where property owners derive a great deal of revenue from billboards, and the city council has nevertheless voted to remove those billboards. Mm-hmm. So it's interesting that in some instances the property rights come into effect.
Well,
in
if
some instances,
if it's a billboard that's not meeting the regulations, then of course that would matter if you owned it or the billboard industry owned it. That's true. And sometimes property rights have to meet the rules and regulations that we set forth. But on the other hand, if you say to the billboard owner, here's the sign, and the billboard owner wants to get rid of it or keep it himself, not from anything the city says, they really can't, can they?
I'm not sure I understood your question. But to get back to your previous point, which I think will answer your question, any decision any governmental body makes, the way our system is set up, checks and balances, is that can be reviewed by a court to determine whether it was a proper exercise of discretion. And the decision of the lower court can be reviewed by a superior court to determine whether that was a proper exercise of discretion.
And the alacrity involved is really amazing.
Well, the beauty of the process is that eventually there's a decision, and that's democracy, that's Constitution in action.
And that's okay. I agree with that. I agree with it. I'm just saying I have never seen a billboard removed yet, and I've never seen it move speedily through the courts for different reasons of a lawyer not being able to attend or something like that. These are just frustrations I'm throwing out right now because it feels good.
I appreciate that.
Okay.
Madam Chair, Councilman Chris Kempfer here on behalf of Lamar. I think whenever you see any kind of legislation that's introduced or any position that someone is proposing, you look at the, obviously, you look at the entity that person happens to be representing. So in the legislature, when a bill is proposed by the insurance industry, and they say it's designed to help the automobile owner, you need to look at it closely, because it's probably not designed to help the automobile owner. When the trial lawyers introduce something, you can bet your bottom dollar it's designed to benefit the trial lawyers and not benefit somebody else. So when we hear Orion or others say that they're concerned about the property owner, that that's their motivation, is to protect the property owner, you have to ask yourself, is that really where their motivation is? Is that really where the interest lies? Or is it the fact that they're there to protect their own business interests, which I'm not saying are inappropriate or improper, but it's just kind of too easy to veil your arguments with things like, what about the property owner? When the real thing you're saying is, I want to be put in a position where I can do something to further my own interests. So I'm just saying, let's just forget about all this. Yes, does the property owner count? Absolutely. But that's not the issue that is being advanced by those who are interested in this fourth provision. Now, the thing is, with the first three items, we have complete agreement. That's kind of unusual, that after you work as hard as you have, and Chris Knight was incredible, and his group was incredible in coming up with something that worked for those three items. I don't buy the fact that sitting down together, you can't find a resolution to something. I mean, I've been told in homeowners meetings that there's no way we can work it out. And you've seen it at the end of a homeowner meeting where you stand, or at the end of a council meeting, you're standing up there and the homeowners are thanking us for working together and we're thanking them, and you come up with something. I never buy the fact that conversation doesn't help, that compromise can't be reached, that working together is a waste of time. And I think that's what we're hearing, and I just don't buy it. You have 90% of the billboard industry, you have 100% of the billboard industry agreeing with those three items. You've got 90% saying this fourth one creates a problem, but we're willing to take some time, sit down, maybe we can come up with things that no one's thought of yet. And one of the things that I wanted to just tell you about, under the ordinances written now, if you want to get at a billboard that you don't believe is appropriate anymore, this ordinance says that there's a site plan review only. It's not a use permit. So if I have a board in your district, your ward rather, and that board is non-conforming, and you want it down, as this is written now, this really gives you no basis to go get that. And I don't know if you really want to do that. I don't know if that's where you really want to end up, is creating a right in perpetuity for a billboard that may not be in an area where you still want to, where you don't want a billboard anymore. But the point is, that's all tied together into that one issue as to what we can do working together to see if there's a way we can get at resolving that remaining issue. And I just refuse to believe that we can't work together and do it. And if we can't, now, you said on an earlier argument, and that's true, there's not very many days between now and the holidays are through, but I just can't believe that if we don't sit down as a group, that we can't, and we're both willing to compromise and work something out, that we can't come up with something. And if we can't, what's the harm? We're back here then in February or March saying to you, you know what, we tried but we couldn't do it. But at least you have an ordinance now that everybody's agreed to, and it's passed and it's out there, and you've met the obligation, and we've met our obligation to the legislature. So I would just like us to have an opportunity to work together to see what we can do to come up with something. And if we can't, we're in no worse position than we are now. Thank you.
Anybody else from the audience? Anybody here that would like to make an additional comment?
Good afternoon, Madam Chairman,
Which you can't.
committee. I spend the day at Clark County. I've really not had a very good batting average, so I don't have a heck of a lot to lose here. I thought the argument of the gentleman representing Clear Channel was extremely cogent, very tight, very logically sound. Also, the Lamar argument was logically sound and tight. I believe that something is better than nothing. I don't really see an advantage to hold up 3 for 1. I don't believe in being stymied. This is a matter of public record, and it really shocked me. MGM Mirage, I believe it was Jim Murin, and it's all on public record. It was either in the Sun or the LVRJ, said concerning their plans for Laughlin, where they were going to build a number of low-income housing units for staff because of the massive shift in the mortgage and the housing situation. MGM Mirage with Kirk Kerkorian, with Jim Murin, with Terry Lanneman said we're stymied. I just don't believe in stymied. I agree that we have the talent, the staff, the leadership, the governance, the accountability on City Council, that the last 25 yards can be won. I have that much confidence in all of you. And I think the good mayor would be much more pleased if we advanced. Now, I hear that there's some kind of conflict between what he might have said one time and another time. I think in his spirit of good sportsmanship and fair play, he would like to have us have 3 go ahead, and we'll catch the other one later. That's all I have. Thanks so much.
Good afternoon. John David Pereira. I'm General Counsel for Orion, and my comments are brief. In June, we met as a committee, industry, with Chris, and these issues came up, and we talked about them. And my recollection was Chris saying we need to speak with one voice, and the ordinance was pretty much as you have it today, with the exception of the word sign owner instead of applicant. And at that time, before everybody left, the industry was okay with the language as it was drafted in June, according to the interpretations that Mr. Knight has given you today, his understanding of the language of the ordinance and how it would operate, which is exactly what you have before you. Since that time, there has been this industry wrangling, and it's not going to go away. And I think what Chris presented to you, based on his interpretations and the intent of that ordinance, is what should go to City Council and is what should be approved. For the industry, for the property owners, for everybody, everybody does have a vested interest. But if you put it aside, the only people that will be talking is industries, and you do leave out the property owner. And I believe the comment that all billboard industries have their own agendas is true, but the property owners never get to participate. And by passing it as it is, everybody will be protected. And if at some point in time the City Council chooses to change it because it's not working out, then at least the power rests with the people in the city rather than out there in the netherworld. Thank you.
Thank you. Anybody else wish to make any comments? Anybody in the audience? Want to get anything off their chest? Okay. I would like to tell you that I did speak with the mayor this afternoon, and he does not have much hope that they're going to reach a resolution. But he hopes they will, but he doesn't have much hope for it. Mr. Councilman Barlow.
Chris, I have a question for you as it relates to the height of the billboards that may be blocked by, for example, a sound wall. And if you can go back over that, because that concerns me from the standpoint of I face that in my ward, whereas a board has been requested to be increased due to the sound wall blocking the side. However, the neighbors on the opposite side that basically sees the board, whether it be in the front yard or the backyard, unobstructed, will be looking at a pole versus a board now, if in fact that pole, the board goes up higher. Was there any thought put in place as it relates to those property owners as far as what they have to look at? But understanding on the flip side, I understand from an industry position that it does them no good either to have a board that no one can see, because of course that board generates no revenue. So where's the compromise between that particular issue?
Very good question, Councilman. The issue is it started out, and if you look in the state statutes as they were proposing it, one, state statutes currently say that the city has to allow a billboard owner if a sound abatement structure is put up that obstructs the view of the billboard company has the ability to go above that. There are no height restrictions. It just says they should be able to get above the sound abatement, and it doesn't say how. And when we started out, I think that and if I misspeak, I certainly hope one of the billboard folks jumps up and says, no, that's not right. But when we first started out, I think the intent is that height limit would be a safety issue for the billboard company, and that there wouldn't be a height limit from the city. That when you get to a certain height, there were a couple of instances in Clark County that were cited to us where they couldn't go above a certain height because to get the folks up there and change the message created safety issues for them. And they said that will be the controlling issue, and I think that's what they had in mind. And from our viewpoint, again, on a quality of life issue as your staff, and looking at what it means to the council to be able to say yes or no to a billboard, we said, I mean, if you go 85 feet, if you go 90 feet, what the driver on the freeway sees is the sound wall, a space between the billboard message panel and the billboard, and it doesn't look like a problem, as you just pointed out. But for the person living down on the ground, especially if it's an elevated freeway, if you have an elevated freeway, you've got, say, a 20-foot, sometimes it's typically 17-foot underclearance, then you have a 20-foot sound wall, you're now 37 to 40 feet in the air, and you want to go another 45 feet above that, you can go up to 85, 90 feet. And we said, when you get to those kind of heights and you have that pole sitting on the ground next to a house in a neighborhood, there's a quality of life issue there. And that's where we came with the 65 feet and said, the current ordinance says 55 feet. Well, if you've got the 37-foot issue and your message panel is 14 by 48, you're going to have a very difficult time getting any clearance above a sound wall at the 55-foot height restriction. And we said the best compromise we can do is give them another 10 feet, that the difference between 65 and 55, and by my own admission, it's trying to keep it at the lowest level and still allow for that height to be raised. Seemed like a reasonable compromise to us, and anything above that would begin to create quality of life issues in our neighborhoods. That judging a 10-foot difference on a pole is a whole lot more difficult than judging, say, a 30-foot or 20-foot difference. So we landed on the 65, one, because we didn't feel that 55 was adequate on elevated situations where we have an elevated freeway plus a sound abatement structure to really get above the sound wall, and we needed 10 feet to do that, and that was as far as we could go to land at that height structure. And you go above that, it begins to have negative impacts on the neighborhood down below.
Might the neighborhoods further, people in other yards further away see the billboard now that didn't see it before if it goes up higher?
And that is part of it, and we understand that, and that 10 feet was really to accomplish what we felt were the objectives of the existing state statute, to be able to get them above it, and the existing state statute does not address height restrictions. And that was part of the compromise that we got out of it with the billboard companies, is that we do have that height restriction, and if they can get it administratively, but if they want to go above it, they're not going to come in and justify the quality of life issue to you as elected officials, those that represent those people in those neighborhoods.
The date of February has been tossed around back and forth as it relates to the fourth item. What would prohibit us from voting on this item and obeying it until February to give more time and more discussion to see if in fact we can reach some formal agreement between now and then?
I think that and honestly, it's your discretion to do what you want. You can obey it till then. But I think what you've heard from the billboard folks and what you hear from us as staff to you is that's kind of like throwing the baby out with the bathwater. We have 3 areas that were the 3 primary areas that were the commitment that we made to the state legislature that we would negotiate with the billboard industry. This 4th area that would be the delayed factor was not a part of that discussion in Carson City. So what we have done is what we have promised the state legislature that we would do. And if you just obey the whole thing because you've got this 4th issue out here now, it's akin to throwing the baby out with the bathwater for us. That it makes sense to move forward to show the state legislature that we were able to bargain in good faith, to work in good faith, and to review ordinances in good faith and adopt in good faith. And then any other issues that are extraneous to that we can deal with at your leisure, at your pleasure.
But
The 3 main issues that we've got really send a strong message to the legislators. But it is entirely your discretion. If that's what you want to do, that's what you do.
well, it doesn't meet again until 2009, right?
That's correct.
Didn't they tell you before the next legislative session have something done? They didn't say have it done by the end of
Actually,
2008.
they told us before the end of the legislative session, get something negotiated, and Ms. Lasovich, representing the industry, and I sat in overnight and worked something out that was then the foundation that we began the discussions from, that satisfied Senator Hardy and the Government Affairs Commission on the Senate side, and satisfied the Assemblywoman Marilyn Kirkpatrick on the Government Affairs Committee on the House side as well. So, I mean, we were given an even shorter deadline than next session.
But
to get
Hardy,
something done before this session.
Hardy accepted all 4, didn't he? And in there, isn't he glowing about your efforts in that letter, and doesn't he praise you for your work?
The letter was written after we drafted the ordinance that had all 4 issues. But the compromise that we used as the springboard of the legislature did not include that issue, did not include the 4th issue.
But he was talking about the 4th issue in there.
I don't know if I can't speak for him on that. I know that the ordinance that we provided him had that issue.
So when are we anticipated to bring this item back or to give the legislature some formal update? When does that take place?
We have been providing updates to both Senator Hardy and Assemblywoman Kirkpatrick as we've gone through the process. When it passed through the council, as it passed through the planning commission, we provided them an update. And we've spoken with Senator Atkinson, who was the sponsor of the bill to begin with. So at least kept those that were involved in that issue apprised of. Don't know that there would be a formal report back to the legislature. The issue would be is if we adopt this, we would hope that there would be no legislation in the 2009 session whatsoever. It does not guarantee that that won't happen, but it puts us in a very good position to go to the state legislature and say to the legislature, we have done what you asked us to do.
So in essence, you're saying that 2009 will be that point to argue that point if in fact it were to occur, correct?
In terms of the property owner versus billboard owner issue?
No, I'm just saying just the overall report.
Yeah, I don't believe that we would give a report back in the 2009 session.
I'm saying if the issue were to come back up in the 09 session,
Oh, I'm sorry.
that will be the formal platform to raise that issue as far as what we've done to meet their
Yes.
recommendation.
If there were legislation that came out, that's what we would do.
Yes. So in other words, there's no formal update between now and the legislative cycle that we must report back to them.
You're right, there is not.
So that's correct?
Yes.
Okay.
Could I ask another question? If we move due pass in its current, as it is currently written, would that include the 3 or the 4?
It would include the 4, and it would include the 4 the way the city attorney's office has drafted it, that's neutral on the issue.
So our move pass as currently written would be to include all. Okay. Is there anybody else who wishes to make a comment? I think I've commented out.
Okay. At this time, I would like to move for due pass
As currently written,
as currently written.
I second that. All in favor?
Aye.
Aye. The motion passes.
Sorry. Citizens participation.
Oh, yes. Excuse me. Anybody else who wishes to say anything for the citizens' comment part? Then the meeting's adjourned.
Thank you.